find here is not just that very narrow finding of the Supreme Court in the Bustamante case, but a very enlightening discussion that proceeds just a page or so prior to the ruling of the court, a discussion that involves custodial versus non-custodial situations. And the court in the Sneckroth case, it seems to me, took some pains to labor over the distinction between custodial interrogation as it involves Miranda, as it might be distinguished from non-custodial situations where a person is asked for a consent to search and no advisement is given. And if the court will give me a moment, it's a long opinion. I don't have my marked copy here. I've got a larger copy. But in essence, I think what the Bustamante court was saying was that we have inherent in the custodial situation and custodial circumstances potential for coercion. And that, of course, is the very reason why the court in Miranda required the defendant be read his rights, his right to remain silent, his right to counsel, and so on, and that is an absolute right, and that right is that of every suspect in custody who is being interrogated. And the analogy, or the distinction, as it were, between Bustamante and the facts of this case is that it's clear that I was in custody, that I was not free to leave. I think the facts of this case show that I was being questioned and otherwise interrogated by police officers prior to a reading of any Miranda advisement. And what we see here is the beginning of a course of conduct on the part of officers at the scene in this search, whereby there was a systematic avoidance of taking into consideration not only the Fifth Amendment, but the Fourth Amendment. It's the testimony of Sergeant Hayward that he did not read me my Miranda rights prior to his initial search, that he did not advise me that I had a right to refuse consent to search my car if such a request to consent had been made. And I think I know that what I'm asking the court now is to distinguish this case from the Bustamante case on the basis of custody versus non-custody, and then examine, as all the case law requires, examine all the circumstances surrounding the search which have been brought forth through testimony heard by the court, to examine the totality of the circumstances.
Have you read Watson since Bustamante?
I recall seeing the case, but I can't say that I've read it, Your Honor.
All right, go ahead.
That based upon my analysis of the circumstances surrounding the alleged consent, there are these circumstances which I say weigh against finding that the consent was freely, voluntarily, and knowingly given, and which would detract from any attempt by the state to prove by whatever burden they have to prove it that such a consent was legally obtained. The first would be, as it's been demonstrated, that there was no Miranda warning prior to the alleged request for the search or the actual search. Now, certainly, the law is clear that no such warning is required, but it is one of the factors that courts have looked to. It's one of the factors, one of the circumstances. The second would be the lack of advisement that I had the right to refuse the consent to search. And I think that has been brought out in testimony this afternoon. The third factor, which courts look to and have placed a considerable amount of paid a considerable amount of attention to, is the attitude of the police and the circumstances which would indicate that the person, the defendant, the person in custody, was subject to coercion or intimidation. There's some conflict in the record as to whether the police were hostile or not. It's my testimony versus the officer's testimony. And yet, I think even if one tries to take a middle line and just accepts the facts which are not in conflict, it is clear that I was stopped at an early hour of the morning, that I was alone, I was surrounded by a number of police officers, I was told to go places, and I went places, I was in custody, I was being, again, questioned in the absence of Miranda, and questioned in such a fashion as indicated to me that the police were very upset about the circumstances of the stop. The fourth factor that I think is really important here is something the state will dwell on, and something that I'm going to pay a great deal of attention to, and that's my failure to object, which I have admitted to and testified to. And indeed, I did not object to the search. And my explanation for my failure to object is, and was, and my feelings are the same now as they were then, that when confronted with a number of police officers who I believed to be making demands of me and telling me what to do and where to go and questioning me in the way they were questioning me, and that alone at that hour of the morning, that I really had no control of the situation. And not knowing, and I did not know that I had a right to refuse any intrusion into my automobile, then I really felt I couldn't stop them from doing what they were doing. And that is in fact my testimony, and that is in fact, that's my testimony. The fifth factor is something that I want to make as clear as I can, because it deals with the manner in which the alleged request for a consent was made. The officer's testimony is that he had that flashlight, and he was looking, he said he looked in the car. He looked in that car with the flashlight, and then, after seeing what he saw in there, came back to me and said, "Can I look in your car?" Well, he had been looking in my car. And I don't want to split hairs, Your Honor, but if a trained police officer is going to request to search a vehicle with such ambiguous terms as look in your car, in the same way he describes as a visual looking in the car with a flashlight, to me it fails to meet the requirement of law that a request for a waiver of a constitutional right to be expressed and be clear and be concise. There was no request for a consent search, let alone an advisement that I had the right to refuse any such request. The officer did not say, "May I search your car? May I enter your car and search your car?" or any words that were clear, concise, and explicit. The best we have, if one believes the police officer, is that he said, "Can I look in your car?" And the best he can come up with is that my response was, "Go ahead." And if you believe the police officer, he believed that to be a valid waiver of my Fourth Amendment right, if such a conversation took place. I believe that neither the request nor the reply was sufficiently explicit or expressive or intelligibly given to constitute a knowing waiver. So it's my position that the search of the vehicle on August the 16th, 1975, did not occur pursuant to a valid consent. It's also my position that the state cannot rely on any plain view doctrine. In other words, it's the officer's testimony that he looked in the car and he couldn't put it all together, so he went back there. Obviously, what he saw in the car was not, in his own mind, sufficient to cause him to enter that car believing he had probable cause. I don't think we have any probable cause argument left to the state here. They've got to ride on consent, or they don't go at all.
You object to the search or the seizure? Or both?
Well, here's where we're going. Florida law is clear, and I think by the very nature of the term search and seizure, it is clear that we're talking about two terms that are not synonymous. The process of search and seizure, by its very definition, is a bifurcated process. And because, let's say there's probable cause to search, or there is some exception to the warrant requirement that puts an officer in a position to be in a protected area, does not mean there's probable cause to seize. And this is what I was trying to get at when I was questioning Officer Andrak before, and that is, there must be probable cause to seize, based upon the facts, the circumstances, the information within the knowledge of that officer, and what the court, of course, would believe that a prudent person under those circumstances would do. Even if, of course we're saying the consent did not occur, but even if Detective Andrak was legitimately in the position to enter that car and to search it, my argument is that he did not have probable cause to seize for these reasons, which I was able to bring out to a certain degree. That he knew nothing of any burglaries in the area. He did not know whether or not I had any criminal record.
Possession per se was not a crime.
Well, the possession of contraband, or possession of burglary tools, infers that the officer had to believe that there was an intent to use those, unless they had information in his own knowledge, facts in his own knowledge, that led him to gave him probable cause to believe there was an intent to use those, or those articles had been used as burglary tools. Now, I'm not trying to state, I can read to you the Florida, or the Utah statute on burglary tools, but of course we're not holding the officer to the knowledge of a legal technician, but we do impose upon Officer Andrak knowledge of a prudent and reasonable man, and we have to say, what did Officer Andrak know at the time he seized those things? He knew I'd been stopped, but he testified he didn't really know for what. He knew I was in custody, but not sure what I was in custody for. Didn't know anything about any burglaries in the area. There was nothing that indicated to him I fit the description of a burglar. There was nothing that indicated to him that I had a history of burglary. So I think the rule here is, are the articles seized from my car capable of lawful use as well as unlawful use? But beyond that, do they constitute in and of themselves burglary tools for which they could be seized? Was there probable cause to seize them? The officer's testimony is that under the rubric of the burglary tool statute, he seized a pair of handcuffs. Pardon me, burglary tools, or handcuffs, are per se tools which cannot be used in the course of a burglary. If you use handcuffs, it seems to me that it becomes a robbery by its very nature.